Ladies and gentlemen, we're going to go ahead and get started. We have a couple of folks on their way. But Chairman Powell, would you like to come and present your bill? Okay, and we are working from a substitute to House Bill 993, which is LC 481169S.
Madam Chair, you see before you the substitute at the last meeting that I presented the bill. I addressed at that time what grooming was. Quite frankly, I'd never heard of that term, grooming specific to minors and adults. And because of an incident that happened, and I'm not going to get into names because it's still a pending case. But at that time, there was an 11-year-old girl and her coach at a facility basically started paying all of this unwanted attention, I guess, or unmerited attention. And supposedly some other things happened a few years later, and then when the girl turned 18, committed suicide. So there's no witness to what all happened. But as I said, it's ongoing, so I'm not going to get into what may or may not have happened. Everybody's still innocent until proven guilty. But what it did do, it brought, it made an issue to this type of behavior. And when I was asked certain questions, then found out, well, there's no law about grooming. And the product you see in front of you is the work of the chair and of the Prosecuting Attorney's Council. I wanted to be sure that it was right. I'm not an attorney. Some of us that would probably, this is an issue that a lot of parents might even want to go as far as to take justice into their own hands if that happened, but that's not what the society we live in. So this is the product in front of you. Section 1 is your your definition section. And then the meat of it gets down into lines 24. Line 24, a person over the age of 18 commits the offense of grooming of a minor when such person knowingly and intentionally performs an act in person or through a third party or uses electronic device, computer, social media, text messages to persuade, induce, entice, coerce a minor to engage in sexual offense, trafficking of persons for sexual servitude, sexual explicit conduct, sadomasochistic abuse, sexual contact, sexually explicit nudity, or any offense provided for in Chapter 6 of this title. C, line 30, any person who violates this code section shall be guilty of a felony and punishable by imprisonment of not less than 5 years. D, a person shall be subject to prosecution in this state for any conduct made unlawfully in which he engages while either with a person outside or inside the state boundaries of this state. And that, ladies and gentlemen, is what the Prosecuting Attorney Council has submitted. I'm not an attorney. I wanted to be sure that whatever is put forth would meet constitutional scrutiny, and that's it.
Okay. All right. You do have a question? Representative Kendrick?
I was trying to Google this, but
Sadomasochistic.
Okay. So the definition that pulled up is deriving sexual gratification from both sadism and masochism. Am I pronouncing that correctly?
Masochistic behavior and sadism.
Behavior. Okay. Thank you. I looked it up. Googled it.
Okay. All right. Does anybody have any further questions for the author? Okay. There are two people who wanted to sign up to speak to the bill. Ms. Briones. Am I pronouncing that right? I'm having a brain fart. Yeah. Briones. Okay. I thought it was Briones, but anyway.
Good afternoon. Elaine Briones with the Prosecuting Attorney's Council. I did want to start off with saying we did submit some language to assist with this, but as always, the Prosecuting Attorney's Council, we stay neutral. We take no positions on bills. However, we do want to participate as far as helping to make sure that a bill is constitutional and that it will survive any legal challenges. So I am working from LC 481169S, and to address some of the concerns that Representative Kendrick mentioned about sadomasochistic, we would, in order to perfect the bill, we would recommend that at line 16, that we would remove sadomasochistic abuse. At line 18, remove sexual conduct. At line 20, remove sexually explicit conduct. And at line 22, remove sexually explicit nudity. And that is because those are not actually offenses. Those are descriptions of sexual conduct in some of the sexual offense statutes.
Okay, I'm missing one. Sadomasochistic abuse, check, got that one. Sexual conduct. What was the one between sexual conduct and sexually explicit nudity?
Line 20, sexually explicit conduct, and
Okay.
then 22, sexually explicit nudity.
Okay.
We would also recommend that after line 19, the definition of sexual offense, that we add the definition of trafficking for sexual servitude, which would read, trafficking for sexual servitude has the same meaning as provided in Code Section 16-5-46, just to make that abundantly clear.
So you would add at line 6, you would insert a line, basically, trafficking for sexual servitude as defined by,
Has the same meaning
has the same meaning.
as provided in Code Section 16-5-46.
Okay. Yeah, see, I have to write all this down
Okay.
because Ledge Council isn't here, so I have to make sure that Ledge Council
Okay.
has what it needs, so.
And the next recommendation is going to be at line 25. As Representative Powell said, this is a grooming bill. And as we spoke about at the last hearing, grooming is a pattern of behavior, not just one act, but a pattern of behavior. So at line 25, we would recommend that after the word person, that you insert through a pattern of activity, knowingly and intentionally performs an act. So that we in fact know that this is grooming, a pattern of activity. And that language is well used in Georgia law because that language comes from the RICO statute as
Okay.
well.
Okay, I'm sorry. You just got to slow down. I don't write that fast.
Okay.
So line 25, after person, through a pattern of activity, knowingly
And intentionally performs.
and intentionally.
Madam Chair, I wonder if when she finishes, she can pass her notes along to the legislative council.
I can do that.
That would,
I will do that.
well, oh, okay. Yeah. Apparently my my analyst over here can write faster than I can, so that's good. Because whenever we read it back into the record, that's what we'll have to do, is read it back. So, were there any other changes that you
Yes.
wanted?
Moving to line 28, and this is the last bit of the changes.
Okay.
You would have to delete sexually explicit conduct,
Mm-hmm.
sadomasochistic abuse,
Mm-hmm.
sexual conduct,
Mm-hmm.
and sexually explicit nudity.
So the line would read, trafficking of persons for sexual servitude or any offense provided for in Chapter 6 of this title.
Correct.
Okay.
And those are all the changes proposed.
Okay, all right. Number 11.
I think it was really me, the light's not lighting, so 10. Thank you. Thanks. So I appreciate the changes since we're striking those, can you just tell me one more time why we're striking, like why you're asking us to strike that versus keeping it in there?
Okay, so this is generally a mirror of the federal statute. And the purpose of the federal statute was the underlying criminal conduct that Congress expressly prescribed is the persuasion, inducement, enticement, or coercion of the minor rather than the sex act itself. So what they have to entice them to do is a sexual offense. So sadomasochistic abuse under our code is not technically a sexual offense for which you can be convicted of. It's merely a description of a type of sexually explicit conduct found in the sexual exploitation statute. So all of these things that I've asked to be deleted are not sexual offenses for which you can be convicted of. They're
Okay.
merely descriptions.
But you guys helped write the legislation that Chairman Powell was.
Yes, we did, and after conferring with Mr. Smith and I decided that we would probably be a good recommendation to remove that language.
Okay.
So what we are left with is sexual offense. And to let you know what that means under the code, these are the sexual offenses under the code. If you will give me a moment just to review my notes. So sexual offense under the code is aggravated assault with intent to rape, false imprisonment when the victim is a child, not of the defendants, sodomy, statutory rape, child molestation, enticing a child for indecent purposes, improper sexual contact by employee or agent, incest, a second or subsequent conviction for sexual battery, and sexual exploitation of children. So those are all of the sexual offenses under 1710 6.2. It would also reach human trafficking for purposes of sexual servitude, as well as any sexual offense under Chapter 6.
Okay. And this is the final changes that PAC is asking to make on this one that we know of so far? The changes you've
Yes. I think there is a typo, though. In line 29, it should read, provided in OCGA Title 16, Chapter 6. I think that is simply a typo. You have to put in OCGA Title 16, Chapter 6. And I do have my notes, and I'm welcome to turn those over.
Okay.
It makes it clearer.
Okay. All right. All right. Representative Deloche, you had a question?
Just to be sure I understand what you told us, these things we're striking are offenses. They would be included in one of those offenses that you enumerated. Is that correct?
They are not criminal offenses for which you can be convicted. They're merely descriptions of sexual acts that are contained in some of our sexual offense statutes.
That answers my
Okay.
question.
Thank you, sir.
Okay. All right. Thank you. Representative Kendrick?
Yes, just to clarify, last time we talked about if this was going to be a separate offense or if it had to be attached to it. So on line 27, I think you answered this. In order for a defendant to be charged with this, there has to be an actual sexual offense, and then the prosecution can charge grooming as a part of the elements of the crime for the sexual offense, correct? You can't charge this can't be a separate charge of grooming. There has to actually be an actual sexual offense attached to it.
No, this is a standalone charge.
Oh.
So the act that is being punished, the underlying conduct, is the persuasion, inducement, enticement, or coercion of a minor rather than the sex act. So what the statute does, just like the federal statute, it criminalizes attempting to induce a minor to engage in a sexual act for which any person can be charged with a criminal offense.
Okay, it doesn't read quite like that to me, but thank you for clarifying.
This is a standalone.
Okay. Any further questions from the members of the committee? All right. Taylor Hawkins wanted to be heard from Frontline Policy Action.
Thank you, Madam Chairman, members of the committee. My name is Taylor Hawkins with Frontline Policy Action. Our organization represents many thousands of Georgians across this state very interested in securing family and Christian values. And so we're down here representing those here at the Capitol, and one of those fundamental values is human dignity. And so we've worked on a variety of different human trafficking pieces of legislation and other things to ensure that victims are protected and that offenders are appropriately punished. And we would like to offer our full endorsement of this bill, and we thank the work of we're thankful for PAC and their work in perfecting it. We're thankful for Chairman Powell for bringing it. But we believe that this will ensure that victims receive justice, even if there is a lack of a full pattern that would lead to a conviction under one of the further offenses specified in the code section. And we also believe it will help fill a hole in the law to capture folks early in the process of trying to molest a minor. And that is crucial to ensuring that we protect the human dignity of our children, the most vulnerable members of our society. And so we would like to offer our full endorsement and thank you for the opportunity to speak today.
Okay. Members of the committee, any questions for Mr. Hawkins? Seeing none, thank you.
Thank you, Madam Chairman.
Representative, you're recognized too.
Thank you very much, Chairwoman. So my question is perhaps to the woman who was here previously. So,
Ms. Briones, do you have a question of Ms. Briones?
Yes.
Okay. Would you mind to step back up?
Oh, I'm so sorry. I didn't realize you had left the room.
Yeah, no, she would just.
No, and I apologize if you've covered this before, but my question is, if you have a 17-year-old who's engaging in a relationship, sexual relationship with another minor, and that person turns 18, would they not fall under this statute?
Well, it says a person over the age of 18. So this contemplates an adult being prosecuted, not someone under the age of 18.
Well, correct. So you have a 17-year-old who has engaging in sexual relationship with another minor, and then that 17-year-old turns 18 and continues that relationship. Because under that, this would be, it seems to me, I read it as covered.
You know, that's really going to be prosecutorial discretion. I mean, what this is really contemplating is an adult who is contacting a child multiple times with a pattern of activity, trying to get them to engage in sexual conduct. And, you know, that's just going to be a question of discretion, to be honest with you. But, yes, this does contemplate that only someone who is identified as an adult by Georgia law could be charged with this offense.
Okay.
Yeah, I wonder if there's any language that could be, if we could conceive of any language that would avoid that situation. I would think that situation happens often.
Right, and that would be a policy matter for all of you. You know, a person over the age of 21.
I'm sorry, can you speak into the mic? I'm about to start getting sassy
I'm sorry.
texts from the folks that are watching that they can't hear.
That would be a policy question for all of you. If you wanted to change it to a person over the age of 21, a person over the age of whatever age you deem from a policy perspective would be appropriate. That's really up to you.
Thank you.
Okay, all right.
Anything else?
Representative Gullett, you had a question?
Yeah, for sex offenders, I think it's 48 months is what we use standard, right? As far as the other statutes related to minors, is that my understanding? 48 months plus a day, I think.
Yes.
Okay, so that might be something we could do here. It's 48 months plus a day is, so if you're 19, they're 15. You know, if you're 19 plus a day, so if you're 48 months old plus 1 day older than the person you're engaged with, that would be considered a problem. If you're 48 months unless that is not a problem. So maybe that's what we're trying to address, you know.
Maybe something like that, or
Okay, you haven't been recognized. Okay. Okay, all right. If you'll give me a moment, I will recognize you, Representative Neal. If you'll just, do you want to speak in 6 or 5? Pick one. Oh, I thought it was broken. It's not turning red. Yeah, no, it was still flashing. You just kind of keep walking down the line, and before I can recognize you, you've turned it off and turned it back on somewhere else. So it's like trying to play whack-a-mole up here on the on the little podium thing. So just pick one and stay there. 6, okay, there we go. Now you're live and you can ask a question.
We're live. Thank you to the chair. So I just had a question. So technically in Georgia, you can be charged as an adult at 17. So
Oh, yes, you can.
so how does, like, are you still saying it's a policy?
That's a policy
Option.
question for all of you, yes.
Okay.
Alrighty. Any further questions for Ms. Briones? Yep. Okay.
I appreciate Representative Gullett's suggestion, and I think that's an interesting suggestion. Also, we could consider language that contemplates that the actions, the offense of grooming, begins after the person turns 18, as opposed to starting before he's 18, right, or he or she is 18.
Or we could contemplate the just an age range of greater than 48 months plus a day.
Either solution's great.
Yeah. Alrighty. So, ladies and gentlemen, just to get things moving, what is the will of the committee? There's a motion to pass in several seconds. There are a number of additions and revisions, and I will ask you to follow along. Amendments to the bill. We will be striking lines 16, 17, 18, 20, 21, 22, and 23. Did everyone get that? So we're striking lines 16, 17, 18, 20, 21, 22, and 23. And then we're adding between lines at the end of line 23, we would insert trafficking of persons for sexual servitude has the same meaning as provided in Code Section 16-546. And then on line 25, we would add after person through a pattern of activity. So line 25 would read, grooming of such a minor when such person knowingly through a pattern of activity, knowingly and intention, I'm sorry, I misread that. Grooming of a minor, we're starting at line 24. A person over the age of 18 commits the offense of grooming when when such person knowingly, through a pattern of activity, knowingly and intentionally performs an act in person or through a third party. So they would. So after person, we would be inserting 3 words through a pattern of activity. On lines 28 and 29, we would be striking, after servitude, we would be striking sexually explicit conduct, sadomasochistic. Ugh. Suddenly I can't say it. It's catching. Sadomasochistic abuse, sexual conduct, sexually explicit nudity. So we will be striking through those words. And then the second to the last revision on line 29 would be after provided for in Chapter 6 of Title 16 of the Code. So those are the proposed changes that we have thus far. I would suggest the following on line 24. So line 24, the first line would read, a person over the age of 18 and with an age difference greater than 48 months commits the offense of grooming of a minor when such person knowingly and intentionally performs. Blah, blah, blah. So therefore, Ms. Brianna, would that track, would that be, are we getting to what we need to say? That there has to be we're basically trying to create kind of a Romeo and Juliet carve out where it has to be an age difference of greater than 48 months. Okay. All right. All right. Okay. So those are all the additions that we have. Representative Gullett, you have a question? No. Okay. All right. 17.
Yes, ma'am. Thank you, Madam Chair. So I'm not, as Chairman Powell, I am no attorney, and so I would have a question about a person over the age of 18, and if you would just read that new language that you said with the age difference of 48 months.
Of greater than 48 months.
So what then happens if it's within inside that 48-month age range? Roughly speaking, but if the offender is 18 and the other person is between, 14 and 18, what happens there?
Then they can't, they basically would not be guilty of the offense of grooming.
That was how I understood it. Thank you, Madam Chair, for that clarification.
Okay. All right. Number 16.
That's you.
Yeah, the question was answered. I guess former school board hat here, and my wife's a high school administrator, and so I'm sitting here thinking that the prosecution. I can't use.
Prosecution.
Anyway,
English is hard in this.
It
room.
is today.
I think it's something in the air conditioning.
I haven't eaten.
English is hard.
Prosecutorial.
There we go. Thank you, Chairman Dubnik. Discretion. There are situations which I understand that she was bringing. Our peer brought about the Romeo Juliet concern about a 18-year-old and a 17-year-old, but I do think that when you're considering all of the other efforts that you put into this as it relates to especially through a pattern, and you have an 18-year-old that happens to be an adult and no longer in high school, and they are intertwined with activities in school systems with a 14 or a 15-year-old, and they now have an opportunity to be in a position to create that activity over a period of time until that person is an adult. I think the intent of the legislation, as I've heard it from the previous committee and this one, is there's a stark difference between a couple who has a relationship and they're, happen to be one that's 18, one that's 17, is vastly different than the risk of somebody that could potentially, if that was created, could have a loophole to allow an 18 or 19-year-old to start targeting 14 and 15-year-old people that they might have had a connection with for a period of time. And I want to make sure that we don't create something that's going to be a area that's going to be a loophole for somebody that wants to engage in this activity and try to time it out, because I will tell you, I have heard some pretty bad horror stories, and I just don't. I like all of the changes except for that. That's just my personal opinion, and I wanted to bring that comment just for the committee's thoughts. Thanks.
Okay, thank you. And for everyone's edification, we will vote on that amendment separately. Thank you. So that's Representative Draper. You had a question?
Thank you very much. So, point of clarification: is an amendment on the table?
Well, there is a motion to pass,
Right,
as amended. However, we're going to break the amendments into two parts. The first part is going to be all of basically the cleanup language that we need to do, recommended by PAC. And the second one we're going to do is the Romeo and Juliet exclusion.
and has
So there will-
language. Excuse me, I'm so
So
sorry.
there will be two amendments, and we have not voted on either yet.
has there been language proposed for the Second Amendment?
Yes. The age difference greater than 48 months.
Okay. If you don't mind, Madam Chairman, I'd just like to bring everyone's attention to the language that is used in the statutory rape provision, which I think is an elegant solution that might be applicable here. So in the case of statutory rape, if the victim is at least 14 years old, but less than 16 years of age, and the person convicted of the statutory rape is 18 or less, but no more than 4 years more than the victim, then such person is guilty of a misdemeanor. So in other words, they're still held responsible for their behavior, but it's a misdemeanor as opposed to a felony.
Okay. Representative Slush, you had a question?
Thank you, Chairwoman. I want to make sure, and what I'm seeing here, we see a lot of gangs, younger gang members now, these 18-year-old, young men, and you have the middle school-year-old girls, 14, 15, 16, 17, 18. Now, that's my biggest concern, maybe in us kind of making that gap a little bit higher. I think that they specifically have the 17 and 18-year-old gang members that's actually targeting these younger girls at a younger age, because they know that if it's that older age, they're going to be looked at more in severe penalty. So my concern is we need to make sure this bill is going to send that message out, even to these gang members at 17 and 18 or what have you, that's trying to get these younger people in. So I don't want us to do anything that's going to make them say, hey, let's get the younger people to do it, because we're going to be, just like they do the drugs and everything else, get the younger members to do certain things, because it's not going to hurt them as, worse, as far as the criminal activity. But
Okay. Y'all are admirable, and y'all would make very good defense lawyers. And I appreciate that we're kind of playing devil's advocate. Unfortunately, kind of like the Supreme Court says, let justice prevail though the heavens fall. Sometimes we do have to err. There are machinations that can go on where somebody does kind of slip through a quote-unquote loophole, but we've done that for the greater good so that we don't have a situation where somebody does get inadvertently caught up in this. So, that's just something that the chair would like to see everybody kind of take into consideration as we move forward. Number 6.
Yes, thank you to the chair. So from what I'm hearing, and even referencing the representative making the reference to statutory rape and the fact that it's a misdemeanor, and then the posture I'm feeling from the committee of not wanting to make this a misdemeanor. From what I'm thinking is, when it comes to statutory rape, in my experience, oftentimes the misdemeanor aspect kind of started to address issues where you would have young people that are couples, and whether it was consent or not. And I think that's where misdemeanor came. I think when this kind of code was being originated, because when we have instances, even if it is consensual, it's you're getting the misdemeanor, but the misdemeanor tied to the fact that, hey, it's a boyfriend, girlfriend, they're a high school couple, what have you. So I feel as though the safest bet is to leave the bill as is, from the perspective of this is not something where they're consenting or not. It's not a situation where they could be okay with being groomed in this manner. So I feel like the safest bet is to leave the bill as is and just say 18 years or younger, absent of 48 months or what have you. That's just my recommendation.
Okay. All right. Thank you. All right. Having reflected upon what everyone has said and just tracking known language, which is always kind of a better idea, the Second Amendment shall read, a person over the age of 18 and no less than 48 months older than the alleged victim commits the offense of grooming. So I'll read that just one more time so that everybody gets that. This is the Second Amendment. A person over the age of 18 and no less than 48 months older than the alleged victim commits the offense of grooming. And that will be the Second Amendment. Okay, this is a question specifically geared towards the amendment. We need to start wrapping this up. I enjoy the discussion, but it's not meant to be kind of a freewheeling, opining discussion. So number 11.
Madam Chair, I just want to make it clear that if we put that 48 months in there, that simply means for a child that turned 18 in January and a 16-year-old got within the 48 months. If it's any beyond the 48 months, this still applies. Mm-hmm. So all we're doing is protecting those that are within 48 months of the same age.
Yes.
And it would be, I think it's incredibly dangerous not to put this amendment in. In fact, I couldn't vote for the bill if this amendment fails.
Okay. All right. So noted. So does anybody want me to go over the Second Amendment, or does everybody have that kind of in their mind and everybody's okay? All right. So there is so the First Amendment, as we have already spoken about, striking lines 16, 17, 18, et cetera, et cetera. So what does everybody feel on the First Amendment? All those in favor, please signify. I'm sorry, there was a move for the Second Amendment. Is there a second? Second for the First Amendment. There's a move and a second. All those in favor of the First Amendment, please signify by saying aye. Aye. Any opposed? Hearing none, the First Amendment is adopted. The Second Amendment shall read, and just for everybody's edification, I will once again repeat it. A person over the age of 18 and no less than 48 months older than the alleged victim commits the offense of grooming. That will be the Second Amendment. And all those in favor, I'm sorry, there's a move. Is there a second? There's a second. All those in favor of the Second Amendment, please signify by saying aye. Aye. Any opposed? No. Okay. How many are opposed? So there's 4 opposed. All those for?
1, 2, 3, 4. 1, 2, 3, 4, 5, 6, 4.
Okay, it carries. So the Second Amendment is adopted. Now for the underlying motion do pass on House Bill 993, LC 481169S, as amended by the committee. All those in favor, please signify by saying aye. Aye. Any opposed? No. Okay, the motion carries. Chairman Powell?
Lady Chairman, members of the committee, thank you. I certainly didn't realize this was going to be such a complicated and
We are very thorough in producing the legislative gold that comes out of juvenile justice.
you have 3 lawyers, you're going to get 12 opinions about it.
At least they don't send me a bill for it. Thank you. Okay, ladies and gentlemen of the committee, we are through with voting. We do have a bill that's on but it's for a hearing only. I know some of you have other places that you have to be, and that's fine. We are going to have a hearing, however, on House Bill 1209. Representative Clark is going to be presenting that. Representative Clark, the floor is yours.
Awesome. Thank you, Madam Chair. I'm bringing before the committee House Bill 1209, LC 481135. And the reason I'm bringing this bill, it's really a very short bill, but what is currently going on, and it's not a lot going on, but it's affecting kids in a massive way. nationwide and in Georgia. And what it would do is, what's going on, and I think it's a very small percentage of even judges who are using this, but in custody cases and divorces, they are forcing kids into reunification camps and like outside the state, unknown locations. And I think, Georgia's a great state to live, to work, to raise a family. And so what this would do is, and it's been dropped in multiple other states and passed in multiple states, banning the reunification camps of these private camps of sending kids out of state. Just one of, and you can Google this, reunification camps, and you read story after story about what's happening to these kids in these camps. There's very, very little oversight, even knowing about these private camps and organizations. One of them, which you're going to hear today, I have Owen with me, and the law, Ethan's Law, is named after his brother. Just one of them, Family Bridges, Randy Rand, who's the owner of Family Bridges, a program where children are ordered to attend these camps. He was stripped of his license to practice psychology when the California Board of Psychology punished him for unprofessional conduct, ethical violations. Rand attempted to appeal the decision, but the Board of Psychology decision was successfully defended by Vice President Kamala Harris, who at the time was a California Attorney General. But he still, to this day, he runs Family Bridges program, which is kind of mind-blowing. These camps can range from a few days to a few weeks, and they cost tens of thousands of dollars. It could go from, I've heard, from $40,000, $60,000 to $100,000 plus. And it seems like, just from talking to a lot of even a number of judges and others who have not even heard about this, but it is being done by some judges. And from what I'm seeing, while this is being sent out of state, it's just a lucrative business. And then, again, if you can go on Google, and I can send you link after link also if you'd like. But talking about what's happened to these children and the abuse and the depression, suicidal thoughts and all that from going through these camps, being yanked away from the legal guardian and being used in quote for reunification camps, it's just kind of mind-blowing. But I would like, if you have any questions answered, I'd like Owen just to give his story. I think we'll really connect of why I'm carrying this bill and why it's needed in Georgia.
Okay, all right. Would you like to step up?
Hello, my name is Owen Eintzema. I'm 18 years old from Gwinnett County, and I'm here today to encourage you to look at the proposed Ethan's Law. If this law would have been in place in 2022, children like my brother and I would have been protected. This law will help protect many Georgia children by preventing the family court system from using damaging programs like reunification camps that often force abused children back into living with the parent who abused them. My biological parents divorced when I was young, and my father remarried. I was raised in a loving family with my dad, stepmom, and 2 brothers. At the age of 10, I told my dad and stepmom that my biological mother was sexually abusing me and my younger brother during our visits. From that moment on, the family court was very protective of us. I spoke with multiple therapists and investigators, and although they never charged my biological mother, we were protected from having to see her again. But that all changed in July of 2022. I had just turned 17 and returned from summer camp with my brother, and shortly after we came home, my brother and I were told we had to pack our bags, and we didn't know why. My dad drove us to the court building and told us through tears that we had to go talk to the judge. Then this judge told us that we were going to be leaving for a camp in California and would be having to see our biological mom. We didn't know anything about the camp or how long we would be gone. We were escorted out by 2 agents with guns and tasers. My brother was told that if he didn't cooperate, he would be handcuffed. We were furious and scared. If you can imagine how scared and emotional we were at age 17 and 15, just imagine how terrifying this sort of situation would be for younger children. Today, children who have escaped an abusive parent are essentially feeling kidnapped by the court system and being told they have no choice but to leave their safe, protective home and to go live with their abusive parent. It is terrifying. My brother and I did not want to be reunified with our bio mom after the abuse she has done to us. But the Gwinnett County judge in our case did not believe that we had been abused, even though we and our counselors told her. Rather than seeing that my father and stepmother were protecting us, she chose to believe that they were alienating us from our biological mom. We had even gone through official reunification counseling from the past year, and the court's own reunification counselor declared that we should not be reunited with our biological mother. It didn't matter. The judge ordered us to this reunification camp called Family Bridges to be reunited with our mother who abused us. I have read online that many families have been damaged by programs like Family Bridges. Family Bridges is just one example of these types of reunification programs. Children have been killed by their abusive parents in other states when judges ignored warnings of danger. This is why in California they just passed a law called Pakiki's Law to prohibit courts from forcing children into these programs. So back to July of 2022. There we were, terrified, being told that now we had to leave our safe home and go to this program. As soon as the judge told my brother and I that we would be attending this camp, we were escorted by transfer agents. The transfer agents also told me that if I did not cooperate, they would taser or handcuff me. We were terrified to be tasered. We were then escorted to California to attend the Family Bridges reunification camp with our biological mother. When we got there, we were escorted into a large room that held the transfer agents and a panel of people, including our biological mom. It was during this time that we learned we would be separated from our family for 90 days. We were told we could have no contact with our dad, stepmom, or any family or friends from our former life. They cut off all communication with our support system. The next day, we had to watch several videos about alienation. The camp director told my brother and I that the way that they were going to fix our alienation was going to be through their program with our abusive mother and to have no contact with our friends and family. So their plan was fixing alienation with alienation. They wanted me to state that I had not told the truth as a child about the abuse, and I refused. They told me it was a false memory and that I had been brainwashed by my father and stepmother. They said if I did not agree, they might have to keep us in this program for longer. They tried in every way to manipulate us to forget the sexual abuse, but we knew what happened to our own bodies. There was also documentation from former therapists at the time. After the camp was over in California, we were forced to go live with our abusive mother, still with no contact with our family or friends from our former life. We also had to switch schools. I figured we could endure the 90 days, but it turned out that the 90 days was a lie. It ended up being a year. The moment I turned 18, I was released from the program. I escaped through a window at my mother's house, and I came home to my dad and stepmom. But my younger brother is still trapped at our mom's home because he is just 16 and underage. The last thing he said to me before I left was, "Please go and get me out of here." It has been a year and a half and still counting that my brother has had no contact with our father, our stepmother, or other family members and friends who love him. Picture what it is like for an even younger child being forced to live with a parent who abused you, and you cannot have any contact with the people who you feel safe and who love you. It is almost unbelievable that these reunification programs exist in the United States of America. Both the judges and the programs refused our constitutional rights. For example, we were refused the guardian ad litem that we requested. We were not allowed regular counseling. We were not allowed to see and communicate with my family. My dad and stepmom can't even tell me anything about the situation, even today, because I guess the judge told her that they are not allowed to. The court has not followed up on the case, so my brother is stuck in this reunification program unless you guys can take action. That is why I'm here today. My experience at this reunification camp was extremely traumatic. It has greatly affected me and my brother's life. The Family Bridges program would not allow us to see a counselor to sort out all of our trauma, so we were forced to deal with our bad emotional and mental health all alone. My mental health and grades crashed because I felt like no one cared. The court supposedly did this for our sake, which is a joke. It feels like it really didn't matter to the court what the truth was or how we were doing, as long as my biological mother got what she wanted and as long as Family Bridges could say their program was working. Despite the fact that my brother and I have spoken to detectives, defects, counselors, reunification counselors, and even the school counselor at Beaufort High School, the justice system failed us. Today, I'm now living with my father and stepmom in counseling and have broken ties with my biological mother. But as I said, my brother is still stuck in this program and has not been allowed to have contact with our father and stepmother for over a year and a half. And now he is even separated from me since I aged out of the program. He is all alone. I want to tell you that right under our noses, this court-ordered reunification camps have been going on in America for years. By allowing programs and camps to be legal for children in Georgia, we are allowing children's rights to be stolen. This is basically legalized human trafficking. Today, you have the opportunity to change this. You have the power to help the powerless, which is the abused children in Georgia. Children should no longer be victims of this kind of program, their abusive parent, and the family court system. These children are dependent on you to do the right thing. Please do not ignore our cause by allowing this to continue until children like me simply age out of the system. Please don't allow terrified, confused children to be taken from their safe families and put with their abusers. It has been 1.5 years since my brother was removed from our safe father and stepmom. My brother is 16 years old and desperately wants to be reunited with our family. We want to resume a normal life instead of the one that was court-ordered. My brother and I have been robbed of a relationship, living under one roof with our family. Our childhoods have been stolen. I'm now 18, advocating for my younger self, my brother still stuck in this program, and any other children in the state of Georgia who could face this fate if the law is not passed. I humbly ask you to advocate my brother and other children who are silenced. Thank you for allowing me to speak to you today.
Okay, thank you. Representative Clark, do you have anything to add?
No, just that, I mean, I know today's a hearing, but I think it's a bill that if we're putting children first, you know, it's going to help a lot. And I mean, I know Owen, just talking to you after he got out, was just, I mean, he has an awesome faith in Christ, and, you know, he's stayed positive as he could. But I mean, I could not imagine, and we read stories, and you can read stories about these family bridges and others where the outcome was not the same, where the kid came through like Owen, and I mean, I know you're still going through a lot, but you know, that's where these depression, anxiety, suicide, and all that, and you read these stories, you can pull them up on Google. It's happened. Even Britney Spears was one that was pulled all through this. You can go read about that and many other stories. So I think it's a simple bill. I mean, it's small, but it's so powerful, because why are we sending kids out of state with the state to do business, to live, to work, to raise a family? And I think even as crazy as his dad is a legal guardian, but using this loophole of like reunification, it's like, wait, as a judge, they have the power to go, wait, hold on, should it be 50-50? Should it be this? But then instead, no one needs to do some reunification. And then also, they can't see their dad. They get ripped away from their siblings, you know, ripped away from those schools. I mean, you do that to any human being, to the comfort that they find comfort and who love them. That's where things go real bad, or it can go bad. And so I think this is a vital piece of legislation, and would love to, you know, next time to possibly, you know, get a vote. And then I'll be glad to answer any questions if there's anything. I talked to DHS, and I know they had mentioned possibly, because when I was talking with Ledge Council, we put it in Title 15. I think it would go in, I think possibly we can talk more, it should be in Title 19 to do with custody, not foster care. So I'm open to that change, putting it in a different section.
Okay.
If that would, you know, make more sense.
Okay.
But any questions, I'll be glad to answer.
Okay. All right. I'm not seeing any questions. Have you talked to any like divorce lawyers that kind of handle things on the civil side?
I've brought it up to a number of attorneys who handle family law and others. Most of them are blown away. They go, "What are you talking about?" You know, same with the department I just mentioned. Like, this isn't like massively used, but it's this niche. It seems like it's just like when Randy ran. License stripped for life, and he's still running it. I mean, it just blows your mind. This should be not nonpartisan, you know. I mean, it shows you he got stripped. He's still running it because there's this loophole, and how I guess it's reunification camp, you know, and even that should put, you know, alarms going off, going, what's happening? And then there are multiple other stories I read of other organizations also we know very little about, and kids being sent, and same abuse and even worse. And I mean, some of these stories, it's kind of mind blowing. And there's very little control on it. And I know, I've known his family for years. I knew the oldest brother. We served in the military together and all that. It's just heartbreaking, you know, to see this going on. And it's like when it's out of state too, it's like, wait, hold on. I can't make a call. And even in my position, like I don't have any jurisdiction, you know, really. And so, but I don't think we should be using this. I think it's, if you're a legal guardian, you should still be able to see your kids, because those kids need it. Unless a judge can step in, use your power. I'm not trying to take your powers away. You have many powers, and I want you to use them for what's good for the kids. But this loophole is...
You have to use the powers for good, though.
Exactly.
You can't use them for evil.
Putting kids first.
Yes, of course. Seeing no questions, I do appreciate the tenor of the bill is right now, this was just a hearing. I think it was good to kind of get it to the committee and kind of air it out a little bit. And we will, keep you posted as far as how it progresses through the system. Members of the committee, do we have anything else? Seeing nothing, we are hereby adjourned. Thank you.
Thank you.